that it'll come to me in a minute. But if you look at the amount of articles on both sides, one says it's better, the other says it's worse. If you take those together, there's no net difference, but middle income America actually came about during the highest percentage of time unions were at 39%. And the decline in American middle income, I think everyone in America realizes the decline in middle.
Is there a question?
Yes, I'm going to say. Okay. Would you say that is a result of right-to-work states gaining ground and unions losing ground?
I'm not sure how to answer the question because there was such a long premise to it. And again, we can play dueling data with here all day long. You know, you can cite a study, I'll cite another study and raise your one. I mean, we could do that till it's dark, but I think it would be more productive. I'm relying on federal statistics from the U.S. Department of Labor's Bureau of Labor Statistics, the Census Bureau. Right-to-work states average growth twice the rate of their counterparts between 1990 and 2014, made up 18 of the top 25 states. Population growth. The right-to-work states are growing in population. People are voting with their feet, apparently. And again, you can't attribute that to any single cause, but again, that's why I say the underlying issue here is personal freedom and individual rights. Nobody should be forced to pay for something they don't want, didn't ask for.
Any further questions for Representative Lockman? We never quite got to the difference between your two bills.
Yeah.
So could you just briefly, and I mean briefly, summarize, go over the
Sure.
basic premise? We do have the summaries in front of us, but.
Yeah. And I spoke primarily here to 489 in my testimony. 404 would simply bar public employers from being collection agents for labor unions. And the reasoning behind this is labor unions are private corporations organized for political purposes. You read the constitutions of any labor union, they are a private corporation organized for political purposes. So I frankly don't think it is proper to have state government collecting a debt for a private corporation. I don't know of any other private corporations in the state that have a deal where the state of Maine collects debts for them at no cost. So that's the idea behind that. This is too much of a sweetheart deal. It should be at arm's length. The unions should be collecting their own dues.
Would you care to update us on those, since we have new members on the committee, how that came about, that the state of Maine began collecting union dues? Or agency fees?
Yeah, well, the history on it, and again, I would make the argument the Maine State Employees Association and other unions, they got along perfectly fine without having the state being their free collection agent for years and years and years. I believe it started in 03, a contract was negotiated that required all new hires to join the union. And then a couple of years later, all current employees, even people who had come to work for the state of Maine 10 or 20 or 30 years before, when union membership was not a condition of employment, were required. And then in 07, I believe it was an act of the legislature referred to as fair share, I call it forced dues, that made the state of Maine a collection agent. And this 404 is just, it's clean and simple. It's just a sentence or two. It deals with the problem saying, no, can't do that anymore. The union's going to have to collect their own dues.
Any further questions from the committee? Senator Patrick?
Thank you, Madam Chair. So do you think that companies shouldn't have the ability to take out credit union statements or United Way payments or anything like that?
No, I'm thinking just in terms of they shouldn't be acting as a collection agent for, frankly, an adversarial entity that's negotiating with the state. And then it, again, is an organization that is organized for political purposes. I don't think the state should be withholding dues for the Republican Party or the Democratic Party or any political entity.
Follow-up? Any further questions, Representative Campbell?
Madam Chair, you just told him to make it briefly. I don't think you should be pushing. Representative Lockman, let him be questioned and let him answer the questions.
Any further questions from the committee? Thank you very much.
Thank you.
So, we will now move on to calling the sponsor, Senator Cushing. And we're going to open a public hearing on LD 1010, and that to afford public employers flexibility to achieve efficiency and quality in management. And since Senator Cushing is right up there, he will also provide us his testimony in favor of LD 1353, or presenting LD 1353, and act clear that mandatory membership in a union or payment of agency fees as a commissioner.
Thank you, Madam Chair, Representative Prohibit, distinguished colleagues of the Labor, Commerce, Research, and Economic Development Committee. I'm State Senator Andre Cushing. I represent 15 communities in southern Penobscot County, which are part of Senate District 10. Today I'm presenting a bill on behalf of Maine School Management. It finds itself in an odd posture before the committee today, engaged with bills related to unionism, union membership, and fees. This bill is fairly simple in that it doesn't have a great deal of verbiage to it. It relates to a recent case in Scarborough that I think highlights the challenge. Members of the school board determined that they could save $250,000 by subcontracting out custodial work. However, they were essentially told in arbitration that saving money was not a good enough reason to reduce the workforce. The district was left with no savings from subcontracting and a $70,000 lawyer's fee for this arbitration. In another case, the Auburn School District had projected a savings of $1.5 million over 5 years by subcontracting out busing. In order to do that, however, the district had to spend in excess of $60,000 to negotiate the right to subcontract. In short order, school districts are being forced to spend money on lawyers instead of kids and teachers. LD 1010 would give public employers the right to subcontract without negotiation. This means if a school board decided that such a move would save taxpayers money and still maintain quality services, the board could vote to make that common sense decision without a protracted and costly legal wrangle. I believe that in this area of tight local budgets and overburdened property taxpayers, saving the public money is a good enough reason to allow subcontracting for certain services outside of the classroom. It underscores the core mission of public schools, which is to give our students the best education possible. LD 1010 supports that core mission, and for that reason I ask for your respectful consideration and support. Thank you. I'll be happy to answer any questions that I might be able to do, and I believe there is a superintendent available to speak later on in answering some of these questions. Mr. George Henderson.
Thank you, and he will be your designee
Please.
for another particular
Yep.
time for that particular bill.
Thank you very much.
Any questions from the committee regarding LD 1010? Representative Hogan.
Thank you, Senator. Thank you, Senator Cushing. Just to be clear, you sort of asserted that this didn't have anything to do with unions. However, I mean, just right in the summary here, it says that this is, just I want it to be clear to everyone, this bill provides the use of private contractors by a public employer to perform services for the public employer is not subject to negotiation and collective bargaining. So this is part of collective bargaining. I wanted you to confirm that.
Well, thank you. I don't believe it's as much part of collective bargaining, although it's been forced into that realm. This is a question for a school board to determine what are the best priorities for the limited resources they have in their budget to accomplish certain support services for the educational institutions. Custodial services, busing are two areas that I don't believe directly relate to the classroom activities. And when we're talking of the scope of savings that are available, we're still providing jobs for individuals. We're just not doing it through the same system that historically has been used.
Representative Hogan.
Thank you, Senator. But guess if it does have to do with employment, though, is my question. It sounds like I'm not entirely familiar with this situation. I'm excited to ask questions too. We'll follow you. But it sounds like they were subcontracting fuel drive buses, people that work as custodians. That was a negotiation of an employment contract. So that sounds like it would have to do with.
I understand your confusion. I think we've got to reflect on the fact that this is a 180-day school year, that many of these companies that provide these services can provide benefits and other opportunities for people that may not be available when you're providing a 180-day school year. So it goes to the enhancement of the services that they provide without some of the complications that may be engaged in previous practices of having these employees as part of either a collective bargaining unit or as part of a school system that is trying to find quality people, because I think in all positions our school boards and our administrators strive to make sure that the people that they put into schools are going to be edifying to the students and provide for a safe and healthy environment. I'm not saying that they don't do that now, but the question is, as we prioritize the money in school budgets, what's the best use of that money? Getting it to the classroom, the education, or into the support services that may be available at a more competitive rate?
What would, just to clarify, what do you mean at a more competitive rate? Could you please clarify that?
Well, clearly, in my testimony, I pointed out that $1.5 million was potentially on the table in the busing and $250,000 in the subcontracting of custodial services. So I think it's pretty clear that they have done their diligence in the process of reviewing the budget, the line items, just as I'm sure that they're seeking the best possible value they can get for the money they spend on textbooks, athletic equipment, other resources in the school. They're talking about something that is not directly related to the core mission of education, but is necessary to support the work that goes on and the requirements of school districts. We put a lot of mandates on school districts and communities in this state, and to not empower them to find cost savings when we can is, I think, troubling.
Representative Bates?
Thank you, Madam Chair. Thank you, Senator.
Thank you.
With the way this bill is written, it seems fairly broad that it is just a workaround to subcontract not subject to collective bargaining. So would that be limited to simply busing and custodial work? Or would that potentially affect positions that have direct student contact or any other position within that school unit?
I think since you have a superintendent here, that might be an appropriate question to refer to them. I think each school district is going to determine what their priorities are. I think that there are a number of instances where certain things will work more effectively if subcontracted versus having private. So as this bill relates now, it affects two subjects that I can talk to because we have the historical perspective. But I'd encourage you to save that question for one of the superintendents so that you can talk to somebody who has evaluated this.
Thank you all.
Thank you.
I'll defer.
Any further questions? Representative Fector?
Thank you, Madam Chair. Thank you, Senator Cushing. I just want to clarify, did I hear you correctly? You said that that custodial services and school bus drivers don't have a direct impact on a child's education?
In the educational field, I'm not saying that they don't have a role in how they deal with children, but when we're talking about the core mission of schools, I think there are certain support services that we mandate as a policy-making body, that the ability to provide those resources is available in other forms besides having to have a full-time employee of that school district. So in no way am I saying that these people don't have interaction with children, but as you speak of the core mission of education, with the teachers in the classroom and the support services, the custodial services and the busing services have a different effect on that mission than a teacher would, who has certain curriculum requirements and certain obligations to meet standards.
So So just to clarify, a custodial person cleaning a classroom and making sure the environment is safe and healthy, and a bus driver getting students to school on time does not have an impact on their ability to receive a good education.
That's your words, not mine.
Senator Patrick?
Thank you, Madam Chair. It almost seems like there's a financial problem here, which is getting into the collective bargaining process. Are you not worried about the slippery slope that this could go further and get into teachers and other things beyond that?
I think I have great respect for the people we elect to do our work as school board members, to take into account what's appropriate. And part of what's appropriate, I think, is the people who have dedicated themselves to educate our children, to work in that team environment. There are certain services that are, I think, more challenging to fill, again, because of the 180-day school year that we have here. To find people who can make the commitments, in some cases, to drive buses, to do certain custodial work in schools, sometimes is challenging. Those are sometimes demanding jobs, and companies that have come along and provided full-time employment with benefits, which are very important, as you know, Senator, in today's market, that people can have some continuity in their income year-round and have the ability to have some benefits available. Some of these private sector companies, I think, have provided a valuable role in hiring good people, training them to the more intensive standards that we have. I mean, we all have probably in our lives stopped for school buses. It's not as simple now as just mom and dad are at the side of the road to put somebody on the bus. Many times children are staying there for a period of time unattended, or somebody might be in the house. Tragically, there have been some people that don't respect the laws regarding passing school buses. So drivers have had to have more training and more skills, more understanding. I believe some vehicles are equipped with AEDs or first aid devices. So there's a whole realm of experiences that bus drivers now have to learn. And many of these companies specialize in that. I know in our area, John T. Sear has for years provided busing to a number of school systems. They are able to, through their school program and their contract program, offer full-time opportunities for a number of people, as well as for some people benefits as a part-time person that might not readily be available in some of the rural districts. So I think your comment is certainly something to reflect on, and I'd say if you have a superintendent that you want to address for their particular school district, I'm sure they'd be happy to discuss some of the decision-making they go through.
Real quick, do you think this bill would be here if the legislature gave the 55% that was mandated for citizens?
I think that's a valid question. I think it's separate from the issue here, because we're really not talking here about whether we need to spend more money in certain districts where there may be a decline in enrollment. The question is if school districts are getting the level of funding, which I believe the administration has increased during their time in office, during the current administration, that it would be hard-pressed to say that giving more money would solve all of the problems that are facing some districts. There just may be a need to contract some of this work out. And this is a tool. This isn't mandatory that says that all school districts must subcontract busing for custodial work. Some of them may already be doing that. Some of them want the opportunity without having to go through the battle that they've had to go through. Otherwise, I don't think that Maine School Management would waste this committee or the legislature's time bringing forward a frivolous bill.
Any further questions before we move on to let Senator Cushing present his next bill? I'll be clerk to Representative Bates.
Thank you, Madam Chair. I'll be brief. Senator, one final question. Using the examples that you are more familiar with, let's go with the buses. It's my understanding that in some districts, the bus drivers have their own bargaining unit. Would this, and I guess my fear is that does this inadvertently become a way to just kind of, I guess, for lack of a better term, fire that unit, how would this bill address districts in which the bus drivers or any subcategory of employees had their own bargaining unit that could be potentially replaced by subcontractors?
Thank you, Representative. I am not involved in collective bargaining, so I can't speak directly to that. I've served on a council, but I've not served on a school board, so I would say that might be another question that a superintendent or a member of school management would be better prepared to offer you information on. The objective of this bill, in my opinion, is not in any way to disrespect those people who are working in these jobs and are able to continue if they happen to be part of a bargaining unit. I don't have a problem with that. If that's the decision locally that the school district has chosen, that's the beauty of locally elected officials negotiating for their districts. And there are some districts that have the volume, but there are other districts that have found that making changes is potentially in their best interest. And it may not be directly related to the individuals or the quality of what is provided. That's unfortunately a nature of what's going on in today's society, is decisions are being made for the viability of the system and the economics of it more than the quality of the people who work there. And I think it's unfortunate in some ways, but with the struggle we have in education right now to meet the core missions that we mandate, I think we've got to be sensitive to their requests.
Thank you.
Representative Stetkis?
Thank you, Madam Chair. Representative Bates' question just kind of sparked something in my brain there for a second. So this particular bill, what you're saying is the exact same people that are currently doing the job that they're doing, whether it's a school bus driver or a custodian, if they provide good service at a good value, it's likely that they would continue to do what they're doing?
I can't guarantee that. This is about allowing school districts to have another option. But if somebody is a good employee, as an employer, I would work very hard to make sure that they were taken care of. I would not do this in a manner that is meant to disrespect anyone who's there. But as some of us in life have found, you have to make decisions that are collectively important for the health of the whole organization, and it does affect people's jobs. I mean, we've had situations in our school district where teachers who were very beloved and respected, their positions were eliminated, not because the quality of what they were providing was there, but the ebbs and flows of student populations and the budgetary needs that resulted in some of those roles being reduced, or the number of teachers necessary to teach that particular class during that period didn't warrant a place on the payroll as they had originally had. So this is the same situation. It just happens to be in some of the support services for school districts.
Any further questions? Would you like to move forward with presenting LD 1353?
If that's the committee's wish, I'd be happy to do so. Again, I'm State Senator Andre Cushing from Senate District 10, 15 communities in southern Penobscot County, and Chairman Bolt, Representative Prohibit, and distinguished colleagues. I present another bill for your consideration today, LD 1353, an act to prohibit mandatory membership in a union or payment of agency fees as a condition of employment. The object of this bill is to secure the rights of employees, particularly state employees, to decide for themselves whether or not to join or financially support a union. Not all state employees agree completely with the unions within their profession, and I do not believe these employees should be forced to become members of this union and to pay union dues. Before 2003, Maine State employees were not required to pay union dues whether they chose to join the union or not. At that time, more than 25% of state employees chose not to join a union or pay dues, and their employment was not in jeopardy because of it. I think what we're dealing with here are some similar principles to what was shared earlier, so I don't want to, I've got my written testimony which I will leave the committee to review. The basic fundamental to me is a matter of choice. We are in a very different environment when you are a public sector employee as opposed to a private sector employee. To get a job with the state of Maine is considered by many people a very good opportunity. I think of the, I believe it's somewhere around 14,000 state employees. We have some very dedicated and competent, thoughtful people who work far in excess of the 40 hours to accomplish their job. I respect them greatly for the commitment that they have. But in this case, we've evolved since 2003 into a requirement that they pay a portion of costs associated with benefits that they may or may not necessarily want. It would be as if you were obligated to pay membership into an association that provided a series of services and benefits that you didn't particularly have an interest in or might not want to take part in. Some of us know the frustration of having a cable television contract that gives us a lot of channels that we don't use or want to pay for. And while I don't want in any way diminish the importance of what unions offer to some of their members, the choice should be there in the public sector for state employees to choose whether they want to pay union dues or not. And that's, to me, the simple fundamental of this bill. With that, Madam Chairman, I'll be happy to answer any questions or...
Any questions for Senator Cushing? Representative Herbert.
Thank you, Senator. Again, thank you, Senator Cushing. How is this bill different than the one that was presented by Representative Lockman earlier? They seem pretty similar to me.
They are fairly similar. I think that the question for the committee to decide is, A, if this is a matter of fairness that they feel should be acted on, and if so, if you feel one or the other is more important to be considered and sent forward. I think it's pretty clear that there's some passion on both sides of this issue as well as on the issue of right to work. It's engendered a lot of participation this morning, and I think that's helpful for the committee in many respects. To me, the question that I present to you, and I was asked to share this bill on behalf of the governor's office. In their negotiations, I think it's become clear to them that there is a significant sector of state employees that would like to make that choice of not being compelled to pay union dues.
So that, not a large difference between...
Not a large difference.
So you're not sure what the motive of the administration was to submit a bill so similar?
I don't want to speak to their motivation. I believe someone from the administration will be here to make their presentation, and not that I'm trying to evade the question, but out of respect to the fact that it's going to be a long day to cause us to go through repetitive testimony on these issues, I don't think it's respectful to the folks who are here or the committee, but I'm certain that someone will be happy to talk to you from the administration standpoint.
Any further questions for Senator Cushing? Seeing none, thank you very much. Oh, sorry, Representative Bates.
That's all right.
You'll be quick.
Thank you, Madam Chair. I had it up, just not high enough,
Oh,
I guess.
sorry.
Just one small facet of the law that I thought was interesting, I was hoping maybe you could speak to, was that it does say that the Attorney General's office, or the Attorney General's office, I suppose, or designee, is responsible for enforcement and is required to prosecute all violations. Now, the AG's office and their scope on many issues varies. Why the requirement to prosecute?
Well, I believe that the Attorney General's office, this is language that directs who would take action if it was necessary. The Attorney General acts on behalf of the legislature and the state in many legal issues. It's sometimes important to specify that so that there is no misunderstanding as who ultimately would be responsible. Otherwise, you could end up with a variety of questions going into court cases to who had priority or precedence to represent the parties on these issues. So that's, I believe, why the language, the directive language is in the bill. Thank you.
Any further questions? Seeing nothing.
Thank you, Madam Chair. Thank you, Committee.
All right. And now we will move on to public hearing on LD 1319, an act to ensure that wages and benefits of Maine State employees serve a public purpose. And Representative Ward. Our committee members are very busy today.
Good morning. Still morning.
Another hour.
Good morning, Senator Volk, Representative Herbig, fellow members of the Labor, Commerce, Research, and Economic Development Committee. I am Carl Ward. I represent the good people of District 131, which includes the towns of Dedham, Orland, Otis, Penobscot, Prospect, Stockton Springs, and Rowan Island. I appear before you today to present LD 1319, an act to ensure the wages and benefits of Maine State employees serve a public purpose. Many of today's bill discussions are focused on the question of union representation and whether employees should have the freedom to choose for themselves whether or not to join a union or be forced against their will to give part of their paycheck to a union. You might be relieved to hear that this proposed legislation does not involve itself with that divisive question, but rather focuses on an idea that every person in this committee should be able to agree on. And that is our fundamental responsibility that each of us agree to bear to make sure that every single tax dollar we take from the people of the state of Maine gets put to work for the people of the state of Maine. Lately, this legislature, and indeed this committee, has been rightly criticized for not meeting that obligation, as the details of the $40 million worth of new market tax credit funding, which was cleverly manipulated by shrewd investors involved in the Great Northern Paper Company failure, and a permissible one-day loan scheme, has come to light on the editorial pages of several of Maine's leading newspapers. This event illuminates and highlights the fact that we in the legislature, and indeed this committee, must do our due diligence and look at this issue, protect the public interest as well as their tax dollars which have been entrusted, and act in a manner that they would approve of. This is precisely why I present this bill, to reinforce the notion that we can be trusted spend their money efficiently on their behalf. In order to look the taxpayer squarely in the eye and pass the straight face test, we must look at a little known but a significant activity that goes in almost every state in the country, including Maine, and it is called union release time. Let me illustrate how union release time works. Imagine the state of Maine contacting a local McDonald's and saying, "We want to donate state workers to your business." The state, with its public tax dollars, will keep paying their salaries, but they will be McDonald's employees. Put them in a McDonald's uniform. Make them sell hamburgers. The state doesn't care. They are yours. After the initial shock and disbelief, the McDonald's owner would no doubt respond, "I'm loving it." Sound far-fetched? Unfortunately, this type of government handout happens every day. But instead of fast food, the beneficiaries are the public employee unions. This means that when the unions dispute salaries, file costly grievances, electioneer for candidates they know will support them after getting elected, the taxpayers of the state of Maine are paying for both sides in every fight. Union release time pits government unions against the taxpayer who pay their salaries, and it's time to end this offensive practice. Under release time, the government employees are released from their full-time jobs in order to do full-time work for their unions, including lobbying and electioneering. All the while, they collect their full taxpayer-funded salaries and benefits. Release time is negotiated as part of collective bargaining contract between public employers and unions. It comes in many shapes and sizes, but are generally distilled down to three different types. The first is full-time release, which let public employees leave their jobs completely to do solely union work. They report to union headquarters, and their government supervisors do not know where they are or what they were doing, yet they receive full pay and benefits, including pensions from the taxpayer. The second type is a bank of hours, which gives unions a certain amount of hours that can be used for a wide range of union activities. While using these hours, public employees can leave their jobs during a shift and do whatever the union wants, including preparing grievances against the government employer. The third type is activity specific, where the government tells the union they can use public employees to perform a certain activity. Activity-specific release time can come with unlimited hours, such as unlimited hours for contract negotiations with the government, or a cap, such as, say, 200 hours for union conferences. The activities performed by employees on release time vary, and often bear no resemblance to duties for which the taxpayer thinks they're actually paying. Moreover, in many instances, release time employees engage in activities that are often in direct odds with the interests of public employers and taxpayers. For example, release time is used to campaign for candidates for public office and lobby legislative bodies on bills, in many cases taking positions on legislation that is contrary to the employer's position. Taxpayers are therefore funding the political activities of a private organization that may be advocating for legislation which many taxpayers may vehemently disagree with. Additionally, release time is commonly used to initiate and file grievances against the public employer. This is tantamount to a company paying several full-time employees to petition other employees to file complaints against the company that the company must then resolve. Release time is also rarely used to negotiate over wages, benefits, and other conditions of employment. In these circumstances, a public employee being paid public wages is negotiating for private benefits with another public body. When release time employees use release time to negotiate over wages and benefits, taxpayers are literally funding both sides of the negotiation with no seat at the table themselves. Talk about taxation without representation. It was impossible for me to do an exhaustive study of all public employee collective bargaining agreements in Maine, and there are many. But in just the first 4 Maine State Employee Association's Local 1989 bargaining unit agreements for the current period, I did indeed find very deep inside these incredibly costly provisions. And I would ask you, there was a second handout I think Diane might have handed out to you, which shows just a small section of one of the agreements. There are some cover pages for different bargaining units in that attachment, and those are the 4 that I looked at, and they each contain the same provision. And I stopped there, because there's literally dozens of them. So to be crystal clear, with union release time, every Maine taxpayer compensates people to not work on the taxpayer's behalf, but instead, instead to lobby taxpayers for more money and more perks. It sounds unbelievable, doesn't it? But it's true. In fact, a recent report in the Wall Street Journal conservatively estimates that nationwide union